Well, a very warm welcome to everybody joining us for the first webinar that we're doing of 2021. And in response to popular demand, we've slightly changed the timing. So this is now the Thursday midday webinar. And in case I forget to say at the end, let me give you a plug for the next webinar. It's not next week, it's on the 28th of January, and it is on cross-border litigation after Brexit, which is a topic that's going to be close to everybody's hearts at the moment as we come to grips with the arrangements that apply after the end of the transitional agreement. Well, the topic of this webinar is cross-border clinical negligence claims. And I'm going to do my best Chris Whitty and ask Dom to advance the slides when we get to that. For people who didn't hear Dom and me saying this before, please do use the Q&A and the chat functions at the bottom of your screens. We've had a couple of questions in advance of today, for which thank you very much, and we will do our best to deal with those as we're going through. For more questions that you'd like to ask or that occur to you during the seminar, please use the Q&A function. We will do our best to keep an eye on it as we're going through and to try and answer either in writing or by incorporating it into what we're saying as we go along, or potentially at the end. So please do use that. Feel free to use the chat, which I can see lots of people have already been doing. And as I say, we'll be doing our best to keep an eye on both of those as we're going along. And we do welcome questions. It always makes it more interesting for everyone when it's a bit interactive. So yes, what we're going to be covering today are specific issues in cross-border clin neg cases, particularly which defendants, who do you sue? Jurisdiction, how do you make sure that the English court has jurisdiction, or if you're a defendant, what arguments are there to the English court should have jurisdiction? Also the question about applicable standards, a topic which travel lawyers are completely obsessed with, but obviously is relevant in this context. And then that feeds into the question of choosing experts. We also have issues of applicable law, which is the applicable law against which defendants. And then finally, quite a complicated issue, which is contribution claims, which happily Dom, rather than myself, is going to be dealing with. Now, if I can just advance the slides, many thanks. The answers to these questions are going to depend on what sort of case it is that you have, because depending on what sort of case it is, the answers may well be different. And the way that Dom and I think it's helpful to categorize cases for these purposes is essentially in three different categories. The first two are contract cases. And contract cases actually divide into two subdivisions. The first are where you have a contract which is also a regulated package, that's to say regulated under package travel regulations. And then you have every other sort of contract case, which is where you have a contract but it isn't a regulated package. And then you have cases where treatment is provided without there being a contract. So for example, in the case of somebody having emergency treatment abroad. And the analysis for the questions which I referred to earlier is going to be different depending on how your particular case fits within these categories. And in some ways, the most straightforward of these categories for claimants is where you have a regulated package. So it's worth having a look in a degree of detail about what it takes for something to be a regulated package and when might a contract for surgery abroad be a regulated package. The reason why this matters is because of regulation 15.2 of the package travel regulations, which provides, as has been set out on here. I'm not going to read it out, but suffice to say the key point about packages is that there is one party, the organizer, who is liable for all of the components. So to quote from the directive that this is based on, there is one trader responsible as an organiser for the proper performance of the package as a whole. So what that means is, if you have a regulated package, then the organiser is liable for all of the components, and including the surgery and the operation. So you have an additional defendant, potentially somebody in this jurisdiction, who can be a proper party to the claim. So certainly for claimants, if there is a package, then the answer to the previous questions becomes quite a lot easier. It's worth pointing out that packages are supposed to be clearly identified as such in the paperwork, but that's not always the case. And in fact, sometimes the paperwork, certainly in a few cases that I've seen, the paperwork has attempted to assert that the contract actually isn't a package. Well, that doesn't work, because if all of the requirements for a package are met, you can't contract out of it being a regulated package. And that's regulation 30 of the package travel regulations, as I've said on the screen. So what does it take for something to be a package? Well, packages are defined in regulation 2, sections 5 to 6. And if we could just advance the slides, Dom. The definition is quite complicated, and what I've done here is my best to simplify it and try and focus it in sort of cases that we're going to be talking about in the context of this seminar. The main definition of a regulated package means a combination of at least 2 of transport or accommodation. I've put vehicle hire in brackets because I don't think that's very likely in the context of a surgery abroad package. The combination has to be combined by a trader before a single contract on all services is concluded. Or this can be purchased from a single point of sale and selected by the traveller before the traveller agrees to pay, or offered, sold or charged as an inclusive or total price, or advertised or sold under the term package or a similar term. Pausing here, with a holiday package that includes, say, surgery, it seems highly likely that most of the components are going to be combined before the purchaser buys it, because what's going to be offered is flights and accommodation and certain surgery. And really, that's the classic case of a regulated package. And it seems to me, certainly the ones that I've seen have all been packages like that. There are more aspects to the definition than this, but these are the aspects that are going to be most likely to be relevant. If you've got a case that doesn't seem to clearly fit in that, then there is no substitute for actually looking at the regulations themselves. As I say, there is a degree of complexity about them. This isn't the only way that something can be a package, because if you only have one of these 2 components of transport and accommodation, it is possible for there to be a package, if we could advance the slides, where if you have one of the key travel services and, say, surgery as well, if the surgery accounts for a significant proportion of the value and is advertised or represents an essential feature, then there can still be a regulated package. But it can't be selected after the performance of the other things has started. I think that's highly unlikely in the context of a surgery package. We're not going to go on holiday and then add surgery onto the package after you've already departed, I don't think. So this is what it takes for something to be a surgery package, which gives you the advantage that the organiser is liable essentially for the proper performance of the travel services making up the package. And at this stage, I'm going to hand you over to Dom, I think.
Thanks, Andrew. So I'm going to be dealing, first of all, with jurisdiction and about bringing these claims in the courts of England and Wales. Firstly, dealing with the service rules. Of course, many of us used to rely pre-Brexit upon CPR 6.33. Essentially, that rule provided that a claimant could serve proceedings on a defendant outside of the UK without needing to obtain the court's permission, where the English court had jurisdiction under the recast Brussels regulations, the Lugano Convention, or indeed the Hague Convention. But of course, we have now Brexited, and you'll be hearing much more about the impact of that in our webinar next week. But essentially, some of the bases that we used to rely upon to essentially not require the court's permission to serve out of the jurisdiction, i.e. under Lugano and Brussels recast, have gone. And what's interesting to note is there has been an amendment to CPR 6.33. So Regulation 4 of the Civil Procedure Rules Amendment EU Exit Regulations 2019 has now come into force. And that has removed CPR 6.33 subsection 1 and has replaced the words judgments regulations in CPR 6.33 subsection 2 with the new limited exceptions for claims by consumers under the new sections 15A to E of the Civil Jurisdictions and Judgments Act. Now, I appreciate that probably sounds a bit of a mouthful, but essentially, unless a claim falls under one of those exceptions, so the new exceptions of 15A to 15E, it's likely that you're going to need to apply for permission to serve out of the jurisdiction. There is another amendment forthcoming, as I understand it, which I believe has been agreed in principle by the Civil Procedure Rules Committee. And that amendment will allow service out without the court's permission where a contract contains a jurisdiction clause in favour of England and Wales. So do watch out for that. But where does that leave us with these claims? Well, if you have a package contract surgical claim, then of course it's more than likely that it's going to be seen to be a consumer contract and will probably fall within section 15B of the Civil Jurisdictions and Judgment Act. So you probably won't need permission. If it's a non-package contract, then you may or may not. It depends on what the contract says. But of course, what you need to do is, when considering jurisdiction, is demonstrate a jurisdictional gateway under paragraph 3.1 of Practice Direction 6B. Now, CPR 6.37 sets out what you have to show in these applications, and it says that you must show, so emphasis added there, that the jurisdictional gateway relied upon, that you've got a jurisdictional gateway that you rely upon, paragraph 3.1 of Practice Direction 6B, that the claimant believes the claim has a reasonable prospect of success, and that the defendant's address, that if it's not known, and that you've got a place where the defendant is or is likely to be found, or if indeed you do know what that address is, you're going to have to pop that in there. You also need to establish that there's a good arguable case that the claim itself is actually covered by a gateway, as well as that there's a real issue to be tried. And it's worth bearing in mind that the courts will not give permission unless they are satisfied that England and Wales is the proper place to bring the claim. So I've mentioned the jurisdictional gateways already, and there are a number of jurisdictional gateways. You have general gateways and then specific contract and tort gateways, which I want to talk about in a bit more detail. Now, under the general gateways, there is a provision, it's under section, paragraph 3.1, subsection 3, which is in relation to anchor defendants. And you may want to bring your claim within the gateway by way of an anchor defendant. So if you want to bring another party, another jurisdiction by way of your anchor defendant, you're going to have to bear in mind the Vedanta case. And that's the case that I've popped on the slide for you. And in that case, at paragraph 20, Lord Briggs set out what a claimant must demonstrate. So you'll see that the claimant has to demonstrate that the claims against the anchor defendant involve a real issue to be tried. If so, that it's reasonable for the court to try that issue, that the foreign defendant is a necessary or proper party to the claims against the anchor defendant, that the claims against the foreign defendant have real prospect of success, or that either England is the proper place in which to bring the combined claims, or that there's a real risk that the claimants will not obtain substantial justice in the alternative foreign jurisdiction, even if it would otherwise have been the proper place or the convenient or natural forum. If you want to rely upon a tort gateway, that is set out again in paragraph 3.1 of the practice direction, and it states that a claim is made in tort where damage was sustained or will be sustained within the jurisdiction, or damage which has been or will be sustained results from an act committed or likely to be committed within the jurisdiction. Now, if you're considering that gateway, it's pertinent to look at the Brownlee case, which feels like the longest running case ever. So many of you no doubt will know the facts of that case, but I will deal with them very briefly. As many of you who have read the case will know, there was an accident in January 2010 in which Sir Ian Brownlee QC was killed in a road traffic accident in Egypt, and his wife, Lady Brownlee, was seriously injured. They had been staying at the Four Seasons Hotel in Cairo with their family, and Lady Brownlee went on to issue claims for her own injuries, for damages under the Fatal Accidents Act, and for damages on behalf of Sir Ian Brownlee QC's estate. So what did she have to show? Well, as I've mentioned already, she had to demonstrate that the case fell within a jurisdictional gateway, that she had a reasonable prospect of success, and that England and Wales was the proper place to bring the claim. Now, in terms of the litigation, you'll know that there's Brownlee 1 and Brownlee 2. The most recent decision of the Court of Appeal in Brownlee 2 upheld the extensive oversight of the Supreme Court judges in Brownlee 1 in respect of the tort gateway and the meaning of damage. And the main issue ultimately was whether damage was limited to direct damage, i.e. physical injury and or death, or whether it extended to indirect damage. Now, in Brownlee 1, the obiter of the majority indicated that there was no reason to think that the authors of the civil procedure rules were contemplating anything other than the ordinary and natural meaning of the word damage, and said that damage could be suffered by the same person in more than one place. Now, if we fast forward to this year, Lord Justice McComb, when delivering judgment in the Brownlee 2 case, said that he felt strongly inclined to follow the majority conclusion, the majority obiter conclusion in the Supreme Court, and the Court of Appeal did so. Now, that is being heard in the Supreme Court. I believe it's being heard yesterday. I'm not too sure if it's being heard today. I'm sure it probably is. So I'm sure we'll hear all about that in due course. But of course, we know that if the Supreme Court says that damage doesn't have a wide meaning, it will probably really constrain the number of claims that you can bring in this jurisdiction. Finally, you may want to look at the contract gateway. So you'll notice again, I've popped that on the slide for you. Again, can be found at paragraph 3.1 of Practice Direction 6b. So it states that a claim is made in respect of a contract where the contract was made within the jurisdiction, was made by or through an agent trading or residing within the jurisdiction, is governed by English law, or contains a term to the effect that the contract shall have jurisdiction to determine any claim in respect of the contract. And in a further subsection, it says that a claim is made in respect of a breach of contract committed within the jurisdiction. So again, if you want to use that gateway, you have to bear that in mind. What you're going to have to look at when considering whether a claim falls within this gateway is, again, you're going to have a look at the Brownlee decision, and that's the Brownlee 1 decision, because at paragraph 16 there was a discussion about this gateway. So even though Holdings wasn't the relevant party to the contract, it wasn't something that was necessarily something that had to be looked at in terms of the judgment, Lord Sumption decided to draw attention to the gateway nonetheless. And in doing so, he referred to the test which has been applied for many years, namely that in Torres and Miles Far East, which you can see the citation on the screen. And that's where one has to look at offer and acceptance in order to analyse where a contract was made and therefore whether it was made in the jurisdiction. Now, it may well be when you're considering this gateway that the contract stipulates that it will be governed by English law, which of course is very helpful, or indeed that the courts of England and Wales will have jurisdiction of any claim. If not, then you may find there are arguments to be had as to whether the contract was made within the jurisdiction. Now, of course, as we know, there's always a possibility that jurisdiction could be challenged and for forum non-convenience to be argued. The burden is on you to show that England and Wales is clearly the appropriate forum. And what the court will also consider is the availability of witnesses, their location, and the potential for multiplicity of proceedings. So I think it's now time for me to hand back over to Andrew on applicable law.
Thanks, Dom. Well, I'm very pleased to be talking about applicable law because this is something where we don't have an announcement to say this is all going to be very different following the end of the withdrawal agreement, or the rules are complex and just have changed and the answers aren't yet clear. This is because applicable law before the end of last year was essentially governed by Rome 1 and Rome 2. And of course, that remains the case after the end of the transition period as well, because these have been incorporated into English domestic law. So Rome 1 and Rome 2 continue to apply as they did before, essentially. And so looking at this through the context of the different cases that we identified at the beginning, if you have a case where it's a regulated package, it is likely that the provisions relating to consumer contracts would apply. And the rule for consumer contracts is that the applicable law is that of the habitual residence of the consumer. So if you've got an English-based consumer, then the law of England will apply. It's worth just bearing in mind, though, that to be a consumer contract with these benefits of these provisions, it has to be the case that the other party pursues commercial or professional activities in England, or by any means directs such activities to that country or several countries. So in the case of a package, you may have the other party to the contract being UK domiciled, as I've said. It may be that you have a doctor who comes over and does consultations in England sometimes. I've certainly seen both of those. If that's the case, there'll be no difficulty at all in establishing that. The other issue, though, is that if it's not a package case, you need to be aware that these may possibly not fall in the consumer provisions, depending on precisely what's covered by the contract. Because if we could just advance the slides, Dom, if none of the services are carried out in the place where the consumer lives, then the consumer provisions don't apply. So what that may mean is, if you have a contract for, let's say, accommodation and surgery, with the surgery being a very considerable part of the value of the package and the purpose of the package, as I said earlier on, that could be a regulated package. However, if none of the services are taking place in the country where the consumer lives, then the consumer provisions don't apply. So that is a potential pitfall to be aware of. And so you need to look at what are all of the services that are being provided under this contract, and the issue about whether the other party is pursuing commercial or professional activities in the place where the consumer lives, or directing activities to that country. So that very briefly deals with the question of contract cases. Now, if we have a non-contract case, then there's a different slide on that, Dom, if you could advance it. This is a slide that I added at the last moment, so I'm delighted that it's made its way onto Dom's screen. But if we're not in a contract situation, and I gave the example at the beginning of, say, emergency medical treatment abroad, then this is going to be Rome 2 rather than Rome 1. And the general rule then is that the applicable law is the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred, and irrespective of the country or countries in which the indirect consequences of that event occur. Now, that's slightly complicated, and probably more complicated than is required in this situation. So unpacking it a bit, it's talking about the damage and not the indirect consequences. So to go back to something that Don was talking about before with the tort gateway, for these purposes, we're not giving a wide definition of damage. It is the damage itself, not the indirect consequences of the damage. I don't think we're likely to need to worry about the difference between the damage and the event giving rise to the damage, because in the context of clinical negligence, it seems to me they're always going to be the same place. And what it means is the general rule is going to be, it's the law of the country in which essentially the medical treatment occurred. And sorry, I think we're on the wrong slide, Dom. Do you mind just forwarding it forward one? Here we are, Rome 2. So the general rule is the applicable law in which the of the country in which the event giving rise to damage occurred. However, there is a get out if it's clear from all the circumstances that the tort is manifestly more connected with a different country, the law of that other country will apply. And the regulation talks about you might be able to establish this if you have a pre-existing relationship, such as a contract, closely connected with the tort delict in question. So it's worth giving some thought about where these things might apply, because one situation you could have is an English contract, and then that being with an organiser, as we were discussing, but then the treatment itself, of course, being provided by different clinicians. And there may be reasons why you want to sue the clinicians in addition to the organiser, depending on deep pockets, insurance arrangements, and so forth. Now, if that happens, then you can potentially found an argument to say that the claim against the clinicians is governed by English law as well, because you've got the pre-existing contract. And it's worth looking quite carefully at the circumstances of a given case to see whether you can link the tort with something in England to try and establish a manifestly closer connection, if it's advantageous to have English law applying. And of course, there have been cases about this. One case is Winrow and Hemphill, and there the analysis is, the question is, where is the centre of gravity of the tort, not the centre of gravity of the damage caused by the tort. That's not a case about clinical negligence, it's about a road traffic accident taking place in Germany. In this particular case, the judge considered that the factors connecting the tort with German law included an accident taking place in Germany, the claimant sustaining injury in Germany, the claimant and the first defendant being habitually resident in Germany at the time the accident happened, the claimant remaining in Germany for a further 18 months after the accident, and receiving a significant amount of treatment in Germany. However, there were other factors linking it with England. The claimant and defendant had both subsequently moved to England. The claimant received some treatment in England. The claimant suffered loss of earnings, so some of her damages in England. Also, she had pursued proceedings in England, although that wasn't considered to be a strong connecting factor. And that must be right, because otherwise you could just make this out simply on the basis of where you choose to issue proceedings. And in that case, the judge held that those factors did not indicate a manifestly closer connection of the tort with England and Germany. As I say, that's a different sort of case to one of clinical negligence abroad. And it seems to me that in many of these cases, there is going to be an underlying contract with somebody apart from the clinicians. And that may well be sufficient to found an argument of a manifestly closer connection with England. And I think at this stage, I'm going to ask Dom to advance the slides again. I mentioned at the beginning, of course, travel lawyers are all very much focused on local standards. And the question of applicable standards is very relevant in these sorts of cases. And if you have a contract case, then the place to start has got to be the contract, because the contract may actually specify a particular standard that has to be provided. So I've certainly seen cases like this where the contract has said something along the lines of that standards will be at least those that you would have in the UK. So that's obviously extremely helpful to a claimant in response to any argument from the defendant to say that the standard of reasonable care that was expected of this particular procedure was less in the country where it took place than it would have been had it happened here. As well as cross-referencing with the contract, it's important to cross-reference with the applicable law. And this is because the way that the applicable law treats the standard may be quite different to how that would happen under English law. And I think in particular of some legal systems where there are very strong presumptions in the claimant's favour, for example, which may make quite a lot of this less important if you can establish your claim in a more straightforward way. So it's always going to be, in a case that isn't governed by English law, it's going to be essential to get advice about how the applicable law deals with standards and what it says about what those standards are. In most cases, it's likely that the standard's going to be more or less one of reasonable care, even if it's not exactly the same as the Boland test. And in those kind of cases, it is necessary to give some thought to the possibility whether there may be some difference in standards in the place where the medical treatment has taken place. I have to say, I have a degree of difficulty with this concept because medicine is an international profession, and medics attend conferences all around the world to deal with and exchange best practice. So I think there's a limit to how far this argument can go in lots of cases, but it's important to bear it in mind because it is possible that there may be a difference and the difference may matter. If we think for the moment about vaccinations that are taking place, vaccines are licensed in some countries and not in others. So that's an issue of local standards. So might medication might be licensed in one place but not in another. There might be different rules about prescriptions and quantities that can be prescribed. Let's say, for example, can a child be prescribed a certain medication? So it is possible to imagine situations where there might be a difference in local standards, and it's important to bear those in mind. And the reason why I flag that is because if the parties are instructing experts, you need to give some thought to the question whether the expert that you're instructing is able to say anything at all about the about what reasonable care means in the country in question. Because if your experts can't and the other experts from the other side can, they're obviously going to be at a significant advantage compared to you. So at that point, I think I'm going to hand you over to Dom to talk about contribution.
Thanks, Andrew. So I thought it was quite helpful to touch briefly on contribution claims. So you may want to consider a contribution claim under the Civil Liability Contribution Act if you're acting for a defendant. And you normally see these sorts of cases where a claimant has had treatment on the NHS in this country and they're not satisfied with the outcome and have gone abroad for corrective surgery, which actually has made things far worse. If you're acting for an NHS trust or for doctors who perform the initial surgery in this country, you therefore may want to consider bringing the contribution claim against either the clinic or the doctors in the other jurisdiction who have made matters worse. You would need to look closely at CPR 20.6, and that's something I've put on the slide for you, because the surgeon or clinic is probably unlikely to be a party to the proceedings. And CPR 20.6 subsection 2 permits a defendant to file and serve a notice of contribution without the court's permission, if you file and serve it with your defence, or if your additional claim for contribution or indemnity is against a party added to the claim later within 28 days after that party files his defence, or alternatively at any other time with the court's permission. Now, what you must bear in mind, and this is a slightly fiddly part to all of this, is that Section 1.1 of the Contribution Act essentially refers to you demonstrating liability. So you can see there on the slide that it says that you may recover contribution from any other person liable in respect of the same damage. So there's a likelihood that you may need an expert report from a foreign lawyer demonstrating that. But also you have to be wary of limitation. And the reason being is because there is a caveat, Section 1, subsection 3, which essentially is that if expiry of the limitation period extinguishes the cause of action, when I'm talking about limitation period here, I'm talking about the foreign law limitation period if foreign law applies, then there can be no contribution claim. So it's really with the limitation period is substantive rather than procedural. So that's something you've really got to bear in mind, because it may well be at the stage of proceedings that you're at, the foreign law limitation period, if a foreign law limitation period applies, has expired, but is ultimately the cause of action has been entirely extinguished, then you're going to be in some difficulty. Following that, we've already touched on jurisdictional gateways, and there is a specific jurisdictional gateway for contribution claims, and that's at paragraph 3.1 subsection 4, and that allows a gateway such if a claim is an additional claim under Part 20 and the person to be served is a necessary or proper party to the claim or additional claim. So I thought it was something that I've recently had a case which has touched upon this issue. It's quite interesting. It's not something you see that often, but I thought it might be helpful. But again, as we've already mentioned, there are hurdles to surmount in any event once you get through the jurisdictional gateways. So I hope that helps. But I think that brings us to the end and time for questions. We've rattled through it quite quickly today, Andrew, I think.
We have. I think we've obviously had a good Christmas break and come back very energised and able to deal with everything very rapidly. Well,
I was going to say, I've got a question already.
Well, I know. Well, we've got several questions actually. I thought I would let people know some, when I was preparing for this, I had a look on the internet for some examples of surgery package holidays, essentially. And there are an awful lot out there. So let me give you some examples of quotes about how people are marketing their services. So our cosmetic surgery holidays offer a package holiday deal. That was one. The NHS website actually has a whole section about holiday packages, including cosmetic surgery. One city has a description of itself, I'm not going to say which city it is, saying that it's become a top plastic surgery vacation destination, especially for holiday makers, and a new category which I've never heard of, which are called beauty seekers from the UK. Now, beauty seekers, I think that's about trying to improve your own beauty rather than trying to seek out beauty in other people. But all the same, a lot of these cases are going to be holidays and are being marketed as such, and by that I mean a regulated package. We've just had some suggestions on the chat about which city it is that's become the top plastic surgery vacation destination, and I'm not going to be drawn into that. Well, dealing with some of the questions then, we've had several questions come through about costs, one in the chat and then one in advance of today. And it's important to remember that whatever we're talking about with the applicable law for the contract or for the tort, the questions of costs are matters for the forum, i.e. if a case is being litigated here, then it's going to be the cost rules of this jurisdiction that apply. So you'd expect to have cost budgeting in the normal way, the same rules about quocs and rules about recoverability of ATE premiums and so forth. We've had some questions about who you instruct in terms of experts, following on from what I said. And I'm just toggling here between the Q&A and the chat, so apologies if I look slightly distracted. We've have one person commenting that that their practice in these cases is to obtain evidence about breach from an overseas-based expert, and then causation and condition and prognosis from a domestic expert. And I would agree that that's a very good approach to adopt, because causation and C&P obviously isn't going to depend on the place where this happened, but it is possible that breach of duty will. And certainly at the very least, you want to have an expert who's able to comment on the standards and processes in the country where the alleged breach occurred. But I think splitting it up in the way that's been suggested there is an eminently sensible and likely to be a good way to proceed in most cases, I think. And actually that's observation is really very similar to the observation that we've got in the chat, I think.
I think so. There's another question also that's come in, sorry, Andrew, unless you wanted to add something else.
No, it's fine.
Which talks about whether the meeting, the webinar on the 28th of January, it will be a repeat of this. The answer is no.
It's going to be different panelists, different topic. Yes,
absolutely. So we've of course focused this on surgery claims abroad and clinical negligence claims abroad. That's going to be a different topic. Next week it's life after Brexit generally for cross-border litigation, and I'm safely reassured by Sarah Prager, who's one of our barristers, that it'll be broader and it will also predict the future.
It'll predict the future. Now that is a claim. Is it going to extend as far as lottery tickets and race projections? Certainly, one of my colleagues is very good at predicting the winner of the Grand National, so perhaps it'll extend to that too. And yes, some people are saying they can't wait for that session. So I think so. Now, are there any more questions? Because please do put them on the Q&A if you have any more questions arising out of what Dom and I have been saying.
I can't see any. Oh, we've got a new message. No, just saying that that was helpful. So unless there's any further questions, you can see our emails are on the screen. Feel free to drop us one. We've just had one question come in about claims arising out of vaccinations. Don't know if you want to try and tackle that, Andrew.
Well, I don't think that there are going to be many cross-border cases about vaccinations. No. Because none of us are able to travel at the moment. And I think we probably are going to have some claims about vaccinations, and probably an interesting topic for another webinar in due course, I think.
So I think then on that note, if there's no further questions, and of course, if you have any after the webinar, just drop us an email. But it's been lovely to speak to you all. First webinar since 2021 started.
First webinar of 2021. First webinar post-Brexit as well, which is quite extraordinary.
To get us up to speed with everything. But it's lovely to see all of you. Thank you so much for joining us. And hopefully, my colleagues see you on 28th.
Absolutely. Thanks very much for joining everybody, and thanks for your time, and I really hope it was useful.
Take care, everyone.